The Civil Rights Movement was a substantial and important step for the American people. Although it was a long time for civil rights and equality to be passed in the United States, segregation would eventually end and freedom rights for blacks, immigrants, and people of all kinds were granted. In public places, the Civil Rights Act of 1964 ended segregation on basis of race, color, religion, sex, and national origin. Lyndon B. Johnson signed into law the Voting Rights Act of 1965, which allowed African Americans to exercise their right to vote. On January 23, 1964, the 24th Amendment was set in place, prohibiting any poll tax in elections for federal officials. Loving v. Virginia was a civil rights case of the U.S. Supreme Court in 1967, which involved Mildred Loving, a black woman, and Richard Loving, a white man, who had been sentenced to a year in prison in Virginia for marrying each other. Their marriage violated the Racial Integrity Act of 1924, which prohibited marriage between white people and colored peoples. The decision to invalidate laws prohibiting interracial marriage was followed by an increase of interracial marriages in the U.S. Thurgood Marshall was an Associate Justice of the Supreme Court. Marshall was the court's 96th justice and its first African American justice. He is famous for winning the Brown v. Board of Education as a lawyer. Thurgood was appointed to the Supreme Court on August 30, 1967. He became a judge around the same time that the Loving v. Virginia case was going on. The Civil Rights Act of 1968 provided for equal housing opportunities regardless of race, creed, or national origin, and made it a federal crime to, by force or by threat of force, injure, intimidate, or interfere with anyone. Affirmative action is a policy in which an individual's color, race, sex, religion, or national origin are taken into account by a business or the government in order to increase the opportunities provided to an underrepresented part of society. This bill was passed on March 6, 1961 by President John F. Kennedy. In the 1978 case of UC Regents v. Bake, the Supreme Court ruled that a university's use of racial quotas in its admissions process was unconstitutional, but a school's use of affirmative action to accept more minority applicants was constitutional in some circumstances. Gratz v. Bollinger was a U.S. Supreme Court decision in which the court upheld the value of student body diversity, but decided that the use of race in the University of Michigan's undergraduate equal opportunity program was not narrowly tailored to achieve the university's asserted interest in diversity. Shute v. Coalition to Defend Affirmative Action was a case before the United States Supreme Court, questioning whether a state violates the Equal Protection Clause of the 14th Amendment by enshrining a ban on race and sex-based discrimination on public university admissions in its state constitution minority groups. The current controversies of affirmative action today is that the programs are wholly opposed to the American ideals of personal rights, while those in support of it feel it is necessary for equality. In conclusion, the Civil Rights Movement was one of the most substantial steps for America, and it unified the country as one, regardless of race, color, or religion.